Everyone, please be seated. I want to start by saying this. I've been on this bench for a long time, long enough that very little surprises me anymore. I've heard every excuse. I've seen fear, regret, anger, tears. Most defendants walk into this courtroom carrying some version of those emotions, shouting, "Oh, wait, bitch, let me complete." But on this morning, surprised, the defendant walked in smiling, not nervous, not confused, smiling, and that was the first moment I knew this case was going to end differently. Now let me be clear about something right away. This courtroom isn't here to impress anyone. It's not here to negotiate power or status. It exists for one reason: to decide whether the law was broken and what happens when it is. That's it. Nothing more, nothing less. But as the charges were read aloud, I noticed something I almost never see. The defendant didn't look at her attorney. She didn't look at the clerk. She didn't even look down. She leaned back slightly, crossed her arms, and glanced toward the gallery, like she was watching something amusing. I picked up the police report next. Standard procedure: date, time, location, vehicle description, officer statement. I've read thousands of these over the years, but about halfway down the page, there was a sentence that made me stop reading. I read it again, because in all my years doing this job, I had never seen that sentence written that way before. What the defendant said during that traffic stop wasn't just disrespectful. It wasn't just arrogant. It revealed an assumption that consequences were optional, that rules were flexible, that this situation would end the same way others apparently had: quietly, conveniently, forgotten. That's when I set the file down and looked back at the defendant. And for the first time, her smile faded. You see, this case isn't memorable because of a speeding violation. It isn't memorable because of a citation, or even because of who her father is. This case is remembered because of what happens when confidence collides with accountability. And before this courtroom adjourned that day, one question had to be answered. One question that would decide everything that followed. What do you do when someone laughs at the law, believing they'll never have to face it? When the clerk read the defendant's name, I did what I always do. I ignored the name and studied the person. Age, posture, expression. The way someone carries themselves under pressure tells you far more than any background summary ever could. She was 23, calm, well-dressed, sitting straight, shoulders relaxed, not fidgeting, not whispering to her attorney. She looked comfortable. And in a courtroom, that's not a good sign. This wasn't the confidence that comes from preparation. It was the confidence that comes from insulation, from knowing that when things go wrong, someone else usually steps in to make them easier. Her last name wasn't unfamiliar. In this city, it carries reach, not celebrity, leverage. The kind that opens doors quietly, the kind that shows up in campaign finance reports, charity galas, zoning approvals, the kind that doesn't ask for favors out loud. As the clerk entered her background into the record, education, residence, family, I watched her closely. She didn't react. No tension, no concern. It was as if she'd already decided how this would end. I've seen that look before. It's the look of someone who believes this is a formality, a brief interruption, something that will resolve itself once the right conversation happens outside the room. And then I saw the first detail that changed my posture. The incident didn't happen on a highway. It didn't happen late at night. It didn't happen during a storm or an emergency. According to the report, it happened mid-afternoon. Clear weather, residential street, the kind of place where speed limits exist for a reason. That's when I stopped treating it like routine, because recklessness in the wrong place is an accident waiting to happen. Recklessness in the right place, where people feel safe, is something else entirely. This case didn't begin with confrontation. It didn't begin with an argument. It began with a decision made casually, without hesitation, and without regard for who else might pay for it. And as I reached the next paragraph of that report, I realized something that unsettled me more than her confidence ever could. This wasn't the first moment where she should have stopped. It was just the first time someone wrote it down. August 15th was about to enter the record, not as a date, but as a line that divided what could be ignored from what could not. And what happened on that street next would answer a very uncomfortable question. Was this carelessness, or was it entitlement in motion? August 15th, 4:30 in the afternoon, clear weather, dry pavement. School had already let out. According to the report, traffic was light, the kind of afternoon where people assume nothing bad is going to happen. The defendant was driving a late-model luxury SUV, heavy, Powerful, built to absorb speed in a way that hides how fast you're really moving. The posted limit on that road was 25 miles per hour. She was doing nearly 70. That number wasn't estimated. It was captured by radar, confirmed, logged. At that speed, there's no room for error, no time to react. Whatever appears in front of you, you don't slow down, you collide. Officer Daniel Martinez noticed the vehicle before he ever saw it. The engine, a sustained roar moving far too fast for a residential block. He was positioned near the intersection, watching traffic the way officers do when nothing seems wrong until suddenly something is. He initiated the stop immediately. When he approached the driver's side window, he followed procedure, calm, professional, no raised voice, no assumptions. He asked a simple question, the same one asked in thousands of stops every day. Do you know why I pulled you over? According to the report, the defendant didn't hesitate. She didn't ask how fast she was going. She didn't deny the speed. She didn't apologize. She smiled. Then she asked him if he knew who her father was. Officer Martinez wrote the next part word for word, not because it was dramatic, but because he understood no one would believe it otherwise. She told him her father owned half the city. Then she told him his badge could be gone by morning. That line stopped me cold, because that wasn't frustration, it wasn't panic, it was certainty. The kind that assumes leverage will always outweigh rules. Officer Martinez explained the danger, he explained the speed, he explained that this wasn't a warning. She laughed, not nervously, not awkwardly, laughed. Then she lifted her phone and began recording him, angling the camera just right, not to document, but to intimidate, to turn a lawful stop into public theater. Officer Martinez didn't take the bait. He issued multiple citations, logged the statements, logged the speed, logged the time and location, every detail recorded cleanly because he understood exactly what kind of situation this could become. When the stop ended, the defendant drove away, still smiling, no apology, no visible concern, no sign that she understood how close that afternoon had come to ending very differently. But what stayed with me most wasn't the speed or even the threat. It was what happened next, or rather what didn't. Within hours of that stop, the department received attention that had nothing to do with traffic enforcement, calls, questions, noise that usually follows only one kind of case. That's when I understood this wasn't going to end at the roadside, because speed can be reckless, words can be arrogant, but when both are paired with influence and backed by confidence, you're no longer looking at a mistake, you're looking at a belief. And the system was about to be challenged on whether it would tolerate it. The next part of this case didn't come from a police report, it came from her phone. By the time the stop was documented and the citations were issued, this should have ended. For most people it would have. A bad decision, a costly lesson, and a reason to slow down. Instead, within hours, the defendant uploaded videos from inside her vehicle. Not the speed, not the street. The officer, his uniform, his voice, his face, carefully framed, trimmed, posted with captions that didn't sound angry. They sounded amused, as if the entire encounter had been nothing more than an inconvenience worth sharing for laughs. That's when the case changed shape, because once an encounter goes public, it stops being private misconduct and becomes a message. And the message here was unmistakable. This is what happens when someone like me gets stopped. What struck me wasn't outrage. It was ease. She didn't hesitate. She didn't wait. She posted as if she expected something, support, attention, maybe even intervention. I reviewed the posts carefully, timestamps, captions, engagement, not to judge her character, but to understand her expectation, and that expectation became clearer with every frame. There was no acknowledgement of danger, no recognition of risk, no mention of speed. The violation itself was treated like background noise. The focus was control, framing, narrative. And then came the part most people never see. The pressure didn't arrive loudly, it arrived sideways. Questions began circulating, not because she was innocent, because she was connected. Conversations framed as concerns, inquiries presented as curiosity, the kind of attention that doesn't accuse but still weighs heavily. Officer Martinez didn't respond publicly. He didn't explain himself online. He didn't defend his actions in comments or statements. He trusted the record. The defendant did the opposite. Another post followed, then another, each one sharper than the last, each one carrying the same unspoken assumption that this situation would resolve the way others apparently had, quietly, favorably, without consequence. And then something unexpected happened. Nothing. No public statement, no immediate correction, No visible response from the places she seemed to expect it from. Just silence. The kind that isn't comforting. The kind that makes a room feel tense before anyone speaks. That's when I stopped viewing this as posturing. Because when someone keeps escalating while waiting for rescue, and none comes, the stakes change. At that point, this was no longer about disrespect or embarrassment. It was about whether the law would respond or retreat, and that question was about to be answered sooner than she realized. What happened next removed any remaining doubt, because 3 days later, before the citations had even settled, the defendant was back behind the wheel. Same vehicle, same neighborhood, different afternoon. It was August 18th, just after 2 o'clock. Clear conditions again. Daylight. The kind of hour when people are walking, checking mail, pulling into driveways. According to the evidence, this wasn't a borderline moment or a lapse in judgment. It was reckless. This time, there was no officer with a radar unit, no patrol car positioned nearby. What captured the moment was something far more neutral and far more damning. A doorbell camera, mounted to the front of a home on that same stretch of road. The footage shows the SUV entering the frame too fast and exiting just as quickly. No brake lights, no hesitation, just speed slicing through a place where people expect drivers to slow down. The timestamp was clear, the vehicle unmistakable. When I watched that footage, there was no confrontation to analyze, no dialogue to interpret, no tone to debate. There was only behavior. What I saw wasn't anger. What I saw was indifference. Indifference to the warning she'd already received, indifference to the citations already issued, indifference to the attention her actions had already drawn, as if nothing from 3 days earlier had registered at all. That's the moment this stopped being about arrogance, because arrogance can be corrected. This was disregard. You don't repeat dangerous behavior like that unless you believe the outcome is already decided, unless you've convinced yourself that consequences are theoretical, optional, someone else's responsibility. As I reviewed the timeline, something else became clear. This wasn't escalation driven by emotion. It wasn't retaliation. It was casual, almost routine, as if the first stop hadn't challenged her belief but confirmed it. I can do this again. When the footage was entered into the record, the room changed, not loudly, not dramatically. People shifted in their seats. Conversations stopped. Even the attorneys paused longer than usual before speaking. This wasn't another allegation. It was proof. And proof has a way of tightening the air in a courtroom. I looked at the defendant. She didn't look surprised. She didn't ask to see the footage. She didn't object. She waited. Pause. That kind of calm only comes from certainty, the certainty that something will intervene before consequences land, that someone somewhere will step in and restore balance in her favor. But that certainty had a flaw, because patterns don't dissolve on their own. They don't fade with time. They continue until someone with authority decides they've gone far enough. And as that realization settled across the room, something subtle happened. Exhales. For the first time, this no longer felt like a case headed toward negotiation. It felt like one headed toward collision, and everyone present understood it, whether they were ready for it or not. What followed the second incident didn't arrive with outrage or headlines. Whispers. It came quietly. Not through arguments about guilt or innocence, not through challenges to the evidence. Instead, it arrived in subtler ways. Through scheduling requests, through conversations that lingered a little too long, through carefully worded inquiries that never quite asked what they meant. Can this be handled? No one disputed the speed. No one questioned the footage. No one denied the repetition. They questioned the need. Did this really have to move forward the way it was headed? Wasn't the message already sent? Wouldn't discretion serve everyone better? Because when the facts are solid and the focus shifts to convenience, the concern isn't justice, it's discomfort. I listened, as I always do. But listening does not mean yielding. And as those conversations continued, something else became noticeable. The confidence in them began to thin. The assumptions softened. The certainty faded. What had sounded like expectation slowly turned into waiting. When the defendant arrived for the next appearance, she carried herself much the same way, upright, composed, controlled. But control is fragile when it's borrowed. She checked her phone more than once. She leaned closer to her attorney when the clerk spoke, and when the second incident was formally referenced, the doorbell footage, the timestamp, the location, I saw it. Not fear, calculation. For the first time, she wasn't scanning the room for reassurance. She was measuring it, reading faces, testing silence, trying to determine whether the outcome she'd been counting on was still in play. That was the moment something shifted. Because influence depends on momentum, it depends on the quiet belief that outcomes can still be redirected before they harden. But evidence has weight. Patterns add mass. And once a record reaches a certain point, it stops bending. During that appearance, I denied a request that would normally have passed without comment. A routine delay, the kind granted dozens of times a year. This time I said no, not harshly, not dramatically, simply proceed. The room went still. Counsel paused. The defendant looked up. And in that brief silence, it became clear to everyone present that this case was no longer drifting toward negotiation. It was moving forward. I made it clear that this court would consider the full record. Both incidents, all behavior, every documented detail, no portion set aside for comfort, no shortcuts back to familiarity. 2 dates, 2 violations, 1 uninterrupted pattern. As I closed the file, I felt the balance settle where it belonged. Because when influence loses its leverage, only one authority remains, and that authority was now fully engaged. The next step wouldn't be quiet, it would be definitive. By the time the next hearing began, this case no longer felt theoretical. It felt heavy. What sat in front of the court wasn't a collection of moments anymore. It was a sequence, 2 dates, 2 incidents, same behavior, same location, no correction in between. That matters. As the clerk read the charges into the record, the room listened differently than it had before. Not because the words were unfamiliar, but because everyone now understood what they carried with them. Reckless driving, endangerment, attempted intimidation of a law enforcement officer. Individually, each charge has weight. Together they narrow outcomes. They change what the court is allowed to consider and what it cannot ignore. I watched the defendant closely as the ranges were discussed. This time she didn't sit back. She leaned forward. Her attorney addressed the court next, calm, measured, professional. It was a well-constructed argument, focused on youth, background, future prospects, the kind of presentation courts hear every day, and it did what it was supposed to do. Except for one thing. It avoided the second incident. When I asked about August 18th, the footage, the repetition, the timing, there was a pause, not long, not dramatic, just long enough to register. No denial followed, no alternative explanation, just acknowledgement. That pause changed the room, because once behavior repeats after intervention, explanations lose power. At that point, the issue isn't judgment, it's tolerance. I outlined the scope plainly, no emphasis, no commentary. Those facts limit discretion. I explained what the law allows in cases like this, the license suspension periods, the fines, the custodial range, not as threats, just as parameters, the framework that now governed every remaining decision. That's when the shift finally became visible. The defendant looked at her attorney again, not casually, not confidently. She waited, not for reassurance, but for direction. For the first time since this case began, the assumption that things would resolve quietly was no longer present. There was no familiar path forward, no informal off-ramp, just procedure. I informed the parties that sentencing would reflect the entire record, both incidents, all conduct. No portions separated for convenience, no parts discounted because they were uncomfortable. At that moment, negotiation ended, not because the court refused it, but because the facts no longer supported it. The room went still. This was no longer about whether consequences would follow. It was about how significant they would be, and everyone present understood that the next time this court spoke, it wouldn't be to frame the problem, it would be to decide it. When the court reconvened for sentencing, there was nothing left to weigh, only decisions. I addressed the record the way the law requires, clearly, sequentially, and within the bounds set by statute. This wasn't about making a statement, it was about applying consequences where discretion had narrowed to its limit. First, the license, given the speed involved, the residential setting, and the fact that the behavior repeated after formal intervention, the court imposed an immediate suspension at the upper end of what the statute allows. 3 years, effective that day, no provisional privileges, no hardship exceptions, no early reinstatement requests to be entertained during that period. Driving is a privilege, and this record demonstrated that privilege had been treated as optional. Next, the fines. The court imposed a total financial penalty of $15,000, payable within 60 days. Not symbolic, not negotiable, structured to reflect the seriousness of the conduct and the escalation that followed, not the defendant's comfort or convenience. Then, incarceration. For reckless driving related to the first incident, the court imposed a custodial sentence of 90 days. For the documented attempt to intimidate a law enforcement officer during a lawful stop, an additional 60 days. For the second reckless driving incident, captured on video and occurring just days after the first, another 90 days. Each term to be served consecutively, as permitted when separate acts demonstrate a continuing course of conduct. 240 days total, 8 months. It was the law applied at its outer edge where repetition and intimidation leave little room for leniency. I paused after stating the term, not for effect, but because silence carries meaning. The defendant didn't speak, she didn't object, she didn't interrupt. Her attorney rested both hands on the table and exhaled slowly, not in shock, but in recognition. The kind that comes when the scope of the outcome finally settles. I continued. In addition to custody and fines, the court ordered 200 hours of community service, not administrative placement, direct service with organizations that work with victims and families affected by reckless driving, where consequences are measured in recovery, not theory. Upon eligibility for license reinstatement, full retesting would be required, written examination, practical road test, no abbreviated process, no automatic return to familiarity. As the final terms were read into the record, the defendant's posture shifted, her shoulders lowered, her gaze dropped. The certainty that had followed her into this courtroom did not follow her out. I concluded by stating plainly that any violation of the suspension would result in additional charges and mandatory incarceration, as required by law. No discretion, no ambiguity. When I finished, there were no questions, no arguments, no appeals to comfort, just quiet. And that quiet wasn't punishment, it was finality. Because when the law reaches its limit, it doesn't need to raise its voice. It only needs to be clear. After the sentence was entered and the record was closed, the courtroom cleared the way it always does, quietly, without ceremony. Chairs slid back, files were gathered, voices lowered as people stepped into the hallway and returned to whatever waited for them outside. From the bench, that moment always feels the same. A case ends, not with noise, but with movement, people leaving, doors opening, the room returning to stillness. For the defendant, time was about to change shape. Days no longer measured by choice, but by schedule. Control replaced by structure. The certainty she carried into this courtroom replaced by something unfamiliar and fixed. For her attorney, it was a case concluded. A difficult one. Heavy, but finished. Another file closed, another outcome entered into the system. For Officer Martinez, it was something quieter. He didn't linger. He didn't look for acknowledgement. He nodded once, respectfully, and left the courtroom the same way he'd left the traffic stop weeks earlier, calm, professional, unchanged. That mattered to me, because this case was never about spectacle. It wasn't about embarrassment or public correction. It was about whether the system would respond when tested, not loudly, not emotionally, but correctly. Cases like this don't announce themselves as turning points. They don't end with applause or final words that echo long after the room empties. They end the way most things do, with paperwork finalized, orders issued, doors closing behind people as they walk away. But the effect doesn't end there. Somewhere a neighborhood is quieter because one vehicle won't be passing through it for a long time. Somewhere a police officer knows that the record mattered more than pressure. Somewhere a belief that rules bend for the right name has been forced to confront reality. Not destroyed, confronted. And that difference is important because the purpose of this court was never to break someone. It was to stop something before it broke someone else. When I left the bench that day, there was no sense of victory. There rarely is. Only the understanding that the process had held, this time when it was asked to. Tomorrow there would be another case, another file, another person convinced their situation was different. Sometimes it is. This one wasn't. The law didn't raise its voice. It didn't argue. It didn't negotiate. It simply remained where it always stands, waiting for whoever comes next to test it.